All right. Well, good afternoon. I'm Jacqueline Oscarco, the Director of Conference and Events for CAI New Jersey. I would like to welcome all of our attendees and thank our ultimate partners, the Board of Directors and the CAI team for today's program. We'll be hosting these Wednesday webinars throughout the year. Keep an eye on our calendar on the CAI website. Our next Wednesday webinar will be hosted on April 21st, and that will be featuring Corner Property Management, who will be discussing board meetings of the future, leveraging technology, and Brown & Brown who will discuss aches and pains when handling claims. I'm going to turn it over to Robin for just a minute, our CAI-NJ Manager of Membership.
Thanks, Jack. Again, my name is Robin, and I'm the Membership Manager for CAI New Jersey. I'm just here to remind you all that are participating to make sure that you renew your memberships if you haven't done so already. And that if you have any updated homeowner leader board memberships, please reach out to me. I'll happily get those updated for you. We do have a lot of exciting things coming up for 2021. So for our homeowner leaders, be sure to register for our HOA Board 101 two-day program on Monday, April 12th and Monday, April 19th from 10 to noon, where you can learn the basics of serving your community's board. Our business partner committee is hosting a skill building workshop, Thinking Outside the Inbox, on April 15th. And that's from 3 to 4:30, where you can learn valuable tips and tools on how to get your message across in the most effective way. On April 22nd, you should be registering for our virtual speed networking event. And that's from 12 to 1:30, where you can virtually come face-to-face and connect with prospective clients or just connect with old friends. And then on the 29th of April, we have our FAST committee hosting our virtual paint and sip event. And that's from 5:30 to 7, where all the proceeds will go to the Make-A-Wish Foundation. And then last but not least, we have our PAC Top Golf event, and that's on May 20th, and that's at the Top Golf in Edison. So for more information on these events and any upcoming events that we have, please go to our website, www.cainj.org, to learn more, or you can reach out to me directly, which I will leave my information in the chat. And if you have any other questions regarding membership, I am always here and happy to help. So thank you.
Awesome. Thanks, Robin. Just a few housekeeping rules. You all will be muted. We cannot see you today. But if you do have any questions, please feel free to type those questions into your question box below. If you would like to make sure that you state the panel, like the question directed towards, that would be great. If you do need a certificate for manager credits, please email Jennifer, JENNIFER, at CAINJ.org. And just note that you must be in attendance for the entire presentation to qualify for that certificate. All right. Well, I'm going to introduce our first speakers. We have Martin Cabellar and Tana Buca, who are members of Becker's Community Associations Group, where they represent condominium associations, homeowner associations, and cooperatives in all of their legal matters. Today, they will be discussing COVID-19 vaccinations and how it may affect openings of pools and clubhouses. Welcome. Thank you.
Thank you, Jackie.
Thank you. Just give me 1 second. I'll pull up the PowerPoint. Okay, we can see this. Tana, you can see it?
Yes, thanks.
We got it.
Okay. So Jackie, thank you for the nice introduction, and thank you to everyone at CAI New Jersey for having us today to talk about COVID-19 and vaccinations and how it may affect the opening of your community's pools, clubhouses, and other amenities really as well. As Jackie stated, my name is Martin Cabellar. I'm an attorney with Becker & Polikoff, and with me today is Tana Buca, also an attorney with Becker & Polikoff. We both work as part of the Community Association practice group for Becker & Polikoff. Okay, so coronavirus and opening your amenities. Obviously, the aggressive nature of COVID-19 when it first came onto the scene last year required everyone to take extraordinary measures. This included closing down a lot of the amenities through pools, your clubhouses, your tennis courts, things of that nature. But now spring is here, summer's on the way, and with certain developments as of late, many residents are demanding that facilities such as those pools and clubhouses be reopened. So while we're not entirely in the clear just yet, with vaccinations on the rise and a portion of the population already having antibodies because they had the virus, the question we keep getting from our clients is it safe to open? with regard to that, board members, management, and everyone really needs to be educated on the risks of opening. So to do that, consult with management, consult with your legal counsel, and consult with your professional vendors who are providing the services for your pools and clubhouses and other amenities, and determine your appetite for assuming risks juxtaposed with the procedures and guidelines that you could put in place to try to reduce some of that. Ultimately, if the decision to open is made, there are definitely measures that associations can take and must take in some instances to help prevent the spread, keep your residents safe, and hopefully to the best of your abilities, protect the association from liability. But there is simply no way that you can eliminate all risk. In the past, a lot of the discussion has been surrounded about what are the risks associated with reopening the amenities. Today, we want to kind of gear away from that. We think most people by now are familiar with lack of insurance coverage, the spread in the community, and other risks associated with COVID-19. We want to focus more on those communities that are deciding now to assume that risk and open certain facilities and what they need to be doing. So if you take away just one thing from today, let it be this. If you open, you must institute policies with layers of protection to best protect the association and the board members individually. It's not enough to say you're using some facility at your own risk or posting that sign. When you post that sign, swim at your own risk, you're actually saying swim at the association's risk, because you are signaling to everyone that that facility is safe to use. The association does have some level of responsibility for the health and safety of its residents. And when you post a sign like that, you're actually saying swim at the association's risk. So it's important that you understand that there are certain policies that have to be put in place. And then there are additional layers of protection that we'll talk about today that you should put in place to help protect the association if you're opening these amenities. Let's start with a potential first layer of protection. Requiring vaccinations. To us, there's two key questions here. First, can we legally require vaccinations to use the amenities? And second, should we require vaccinations to use amenities? I think those are two distinct and separate questions, and both should be asked by communities of their legal counsel. Reasonable counsel and reasonable people can disagree as to the appropriate response to these answers. So you do want to go out and seek the advice of your own counsel on this, but we do believe that you could legally require vaccination to use amenities. A lot of people will come and say, well, what about, isn't that a HIPAA violation? HIPAA is not applicable to the relationship between a community association and its residents. Under the current state of emergency that's in place, we do believe that gives the association the authority to require vaccination to use amenities. This is not a situation similar to some people will say, well, you don't require a vaccination requirement for the flu. How come you're doing it for coronavirus? There's not currently a state of emergency in place with respect to the flu. There is with the coronavirus. Note that if you do require vaccinations, you may be required to make accommodations for disabilities, as well as if your community association is an employer. While there is an executive order in place that says employers can require employees to be vaccinated, that is also subject to certain accommodations for disabilities, pregnancy, and religious reasons. Now, with all that said, we don't believe that you should require vaccinations to use amenities. Yes, we think you can legally do it, but we don't think it's in the best interest of the association because there are just too many practical difficulties to requiring this. One is, anytime you adopt any rule, you need to be able to enforce it, and you have to enforce it. And this could be something difficult to keep track of. You're going to have extra people there to monitor who's using the facility, ensuring that they are actually a vaccinated individual. Because you still open up yourself to potential risk if you don't take those steps to make sure that you put in a rule and non-vaccinated people aren't using the facilities. The second difficulty here with respect to vaccinations and people having access to the facilities is, could you face challenges from the community, right? Some people in the community may feel that it's improper for you to do so. And while we think you legally can, it doesn't mean you wouldn't be open to a challenge. It doesn't mean somebody won't institute a lawsuit over that policy. Now, fortunately, consult with your insurance agent, but we do believe that's probably something likely to be covered by insurance. But again, yes, we think you can legally require it, but no, we don't think you should. There's too many practical considerations that make it very difficult to do so. And so with that, I'll turn it over to Tana to talk about some of the layers of protection that you can also put into place with respect to pools and other items, actual facilities that you have. Tana?
Thank you, Martin. Thank you, everyone, for having us and for joining the call today. As Martin mentioned, my name is Tana Buca, and I'm a shareholder at Becker and Polyakoff along with Martin.
Oh, did it go away?
Let's see.
I'm sorry.
No,
Hold on.
I think you're at the right slide.
Can you see the slide still? Okay, there you go.
Yes. Yes.
Right.
Okay. Common area amenities, including the pool and clubhouse, can reopen, so long as it is in accordance with the state's guidelines as set forth by Governor Murphy in his executive orders and in the Department of Health's guidelines. Now, with respect to the pool, most associations are asking to reopen their pools this year, especially since vaccinations are on the rise, and the pool is an outdoor amenity where distancing is more amenable. Executive Order 153 and also the New Jersey Department of Health standards are the applicable guidelines in terms of reopening your pool. Now, it's important to note in the context of vaccinations that this executive order and the Department of Health guidelines do not require vaccines for reopening. So you don't have to implement a vaccine requirement to reopen your pool. Among other guidelines, the pool, if you do decide to reopen your pool, you have to implement a COVID pool operation prevention plan, and that's pursuant to the Department of Health guidelines. You have to implement a protocol for PPE acquisition and distribution to the staff. You have to screen staff by taking temperature readings. You have to designate pool entry points. You have to post signage to alert for people who have illness and require any person who is ill to stay at home. You have to reduce capacity limits at the pool to 50% of the maximum capacity. You have to implement a sign-in sheet requirement for all staff and patrons. And it's suggested but not mandated that you implement a reservation system. Important to note, all of these requirements set forth in Executive Order 153 and the Department of Health standards must be adhered to whether the individuals utilizing the pool are vaccinated or whether they're unvaccinated. In restrooms, you must require foot coverings and limit the capacity to avoid overcrowding. You must require face masks and social distancing when people are not swimming. And of course, 6 feet distancing while they're in the water. All of these requirements can't be avoided. In addition to the pools, most associations are exploring the options of opening their clubhouse. And there are a number of executive orders that were adopted by our governor that apply to indoor facilities, including most recently Executive Order 230. Requirements for opening clubhouses, and this is not, you should consult with your legal counsel. This is not a comprehensive list, but you must limit capacity, restrict those who are feeling ill or have symptoms of COVID-19, require face coverings, and face coverings are required if there's vaccinations or no vaccinations. They're required regardless. Confirm that there's social distancing, post signage detailing the association's policies concerning the clubhouse use, enhance cleaning, and ensure that there's adequate ventilation in the clubhouse. We also recommend that if you're opening your clubhouse, you do the following. Limit certain activities in the clubhouse. For example, you might allow people to utilize the clubhouse to come and read or, utilize the equipment, couches, so on and so forth. But you might not want to host a meeting because a meeting where you have 100 people attending because it would impinge on the capacity requirements. You should also space the furniture and equipment to ensure social distancing. We recommend a sign-in sheet for contact tracing purposes. We also recommend requiring reservations so that to help limit capacity, especially if your clubhouse doesn't have staff on site at all times. You might consider restricting food and beverage at the clubhouse until the state of emergency is lifted. You may also want to limit the hours of operation or stagger the opening times to ensure that your staff can adequately clean and sanitize the clubhouse. You may want to hire additional personnel to ensure that social distancing and sanitization guidelines are adhered to. And you may want to limit access and use to residents only to ensure that residents have the ability to utilize the clubhouse and not open it to guests at this point in time.
So as part of, sorry, I'm getting some feedback on my end. Give me 1 second. Okay, there we go. Okay, so as part of the clubhouses, a lot of our communities have also gyms and fitness centers. And the governor's order regarding the opening of gyms and fitness centers does not apply to community associations. And as a result of that, a lot of residents have said, well, okay, let's open the gyms. It's not that simple. It's not that easy. The association still has a duty of care to protect the health and safety of its residents. So by opening the gym, the association is implying that it's safe to use. So you need to make sure that you're doing something still to ensure the safety of the residents, and you need to make sure that those actions that you are taking are adequate. So what we do think about the governor's order is that it's a measuring stick, right? We think the best practices are to adhere to nearly everything that you can possibly adhere to in Executive Order 181. It ultimately would set and determine a reasonable basis to say this is what constitutes reasonable action in the face of the coronavirus. It was something the governor instituted for public gyms, and at least portions of it ought to apply to community associations that are opening if they're going to be taking some type of reasonable action to protect against the coronavirus. So the types of things you definitely want to follow, as Tana said, with respect to the clubhouse overall, setting certain maximum occupancy limits and perhaps reservation systems in that regard, limiting the amount of people who can come to the gym at one time, providing cleaning and sanitization wipes at every station, spacing that gym equipment so 6 feet of social distancing can be maintained, and keeping that sign-in sheet for contract tracing. What a lot of communities are doing that are opening gyms is with that reservation system, they're only letting one household at a time use the space, depending on how large the gym is. But a lot of the gyms in the communities aren't, as big as your local gym. They're limiting the time that they can use that space and only allowing it to be one household and then cleaning in between each use. Dana, do you want to pick up on the waivers?
Yes, thanks, Martin. One other layer of protection that we certainly recommend in terms of reopening your amenities is requiring waivers. Now, I want to caution everyone, waivers may not be ironclad. And so while they may be beneficial and they may potentially deter some lawsuits, a waiver will not completely avoid the risk associated with reopening amenities. The courts of New Jersey disfavor waivers, and although they can be enforceable under certain circumstances, they will not be enforced if they violate public policy. So what does that mean? Well, the public policy of New Jersey concerning COVID-19 is contained in the governor's executive orders and the Department of Health standards. And if we do not adhere, or if our clients do not adhere to the Department of Health standards in terms of reopening their amenities, but you obtain a waiver and think that that's going to insulate you from liability, that's not accurate, because a court will not enforce a waiver if those standards were not faithfully adhered to and complied with as a result, and a person fell ill with COVID-19. So you can't completely rely on the waivers. Waivers are not enforceable in terms of minors, and they are not enforceable against a person who did not execute the waiver. Another layer of protection in terms of insulating, in terms of limiting liability, is passing a tort immunity amendment to your bylaws. Now, in New Jersey, there's a tort immunity statute, which provides that the association will be immune for, which will give the association immunity from claims for bodily injury on common property in the event of general negligence. To approve a tort immunity amendment, you need a vote of 2/3 of the membership. Tort immunity applies only to deeded owners and their spouses, and it doesn't stop anyone from filing a lawsuit. However, it is a defense if an owner or a spouse of an owner does file a lawsuit against the association claiming general negligence, then the association can seek to have the lawsuit dismissed if there is a tort immunity amendment to the bylaws. Remember, it applies to claims only of general negligence, and so it doesn't apply to gross negligence or willful and wanton misconduct. And tort immunity also doesn't apply to the managing agent, who the association is likely to be required to defend and indemnify. So tort immunity can be useful, but it's not ironclad. Now, I just want to close with, this shouldn't be relied on, but in New Jersey, Assemblyman Mazzeo and Armato, and also Senator Greenstein, have proposed a bill to provide for immunity for planned real estate developments like condominium and homeowner associations and cooperatives within the state. The proposed legislation would offer community associations immunity from legal action regarding any illness, injury, or death from COVID-19 on the property. And we encourage you to reach out to your legislators to voice your support for this legislation. But again, this is not the law right now in New Jersey, and so you shouldn't rely on it. So thank you.
Great. Well, thank you both. You have lots and lots of questions, so let's try and get through some of them. All right, our first one is, would it be reasonable to put questions on a questionnaire if they have received their vaccines?
Yes, I do think you can do that. There's nothing you can do to require the response, but I think you can ask the question. The owner has the right not to respond to that question, but I do think you can ask the question.
Can you address any issues with tennis courts as well as tot lots, play areas with equipment, slide swings, etc.?
There are executive orders that apply to tennis courts and tot lots. There are specific requirements with respect to reopening those amenities. And so I would encourage anybody, they could, of course, reach out to us. Our emails were at the bottom of, and if anybody needs our contact information, CAI would be happy to provide it. But there's specific requirements for reopening those amenities. And again, those requirements must be adhered to, whether the individual using the amenity has a vaccine or does not have a vaccine.
All right, our next question is the pool occupancy 50% of normal or a function of the pool deck square footage?
So, Martin, do you want me to address this or?
Yeah.
Okay, so pool capacity is determined by 50% of the maximum capacity, but another way of determining it is 28 square foot of the pool surface area per bather. So that would be the calculation, whatever the pool surface area is, 28 foot per bather.
All right. What about taking everyone's temperatures? Is that an option at the pools?
You could absolutely implement a temperature requirement, and of course you would have to have staff. At a minimum, all of your staff has to have their temperature taken, but you could require homeowners to have their temperature taken before they enter the pool area.
And do the pool requirements also apply to hot tubs?
Yes.
Yes.
Do you anticipate that the governor will update the guidelines for the pool this summer with more people being vaccinated?
That's
I
the
don't-
hard question.
I don't anticipate it happening this summer. No. I think if you see what the governor has said as of late, cases are somewhat spiking again in New Jersey in certain locations, and I don't see him lifting any of that anytime soon. No.
All right. Do you have an idea of the percentage of communities that will be opening their pools this season? You heard anything?
Yet to be known. I think probably property managers are going to have a better understanding of that. We certainly provide advice and counsel to our clients, and obviously the final decision though is up to the board. I know some of our communities are going to open, but I think the large majority probably still won't, or at least haven't made a decision yet. Rather, I should say, they're all making contingency plans to try to open though. Yes.
And I just want to add to that, boards, this is an individual decision for each community. Boards shouldn't be guided by what their neighbor is doing. They should be guided by what their experts are telling them and what their counsel is telling them and what they can do. If they don't have the money to reopen, to implement all of the safety protocol that is required by the state, then the answer is that they can't reopen, regardless of what their neighbors are doing.
And keep in mind too, I know a lot of times when we go to some of these board meetings, residents will say, but the buildings down the street, all their pools are open. Oftentimes, two things. They're apartment buildings, which are in a different financial and risk circumstance. The owner of apartment complex might be willing to take on that risk because it's the company's risk and not a nonprofit community association's risk. And other times when it is a condo, I've seen that condo is still operated by the developer. They're still in developer control, meaning it hasn't transitioned yet. So the developer, in trying to sell units, is taking on that risk essentially, and is willing to do it. So those are kind of different circumstances. And there's obviously, like Tana said, different from community to community and different from types of communities. HOA sometimes is very different from a mid-rise condominium association setting or a high-rise condominium association setting, because there's more spacing in something like a townhome or a single-family home community versus a mid or high-rise building. So there's all different considerations, not just with respect to pools, but all of the amenities.
I have a question. Face coverings while sunbathing on pool patios, do they need to do that even if social distancing is in place?
They're required to wear face coverings when they're not in the pool.
Okay. If we block off some equipment, put dividers between the machines, do we have to abide by the 6-foot rule?
You do.
Yes.
You do. You had to adhere to all the guidance of the state.
For tort immunity in a
Just to clarify too, if they were talking about gym equipment there, because I want to be on the same page. If they're talking about gym equipment, the 6 foot is a recommendation. So if you're putting up barriers between gym equipment, consult with your legal counsel. They may be of the opinion that that's sufficient. The 6 foot though is sort of the recommendation, because that's what all the current still CDC guidelines are, and we want to try to, the best we can, implement whatever the CDC guidelines are. But if, for example, there's something in the CDC or the governor's executive orders that says with respect to gym equipment, you could put up a space, a divider, for example, that might suffice. But it's the 6 foot, again, we're talking about, that's not a requirement for spacing of the equipment. That's a recommendation.
Wonderful. All right, we do have some more questions, but we are going to move over to FWH for their presentation, and then at the end we can come back and answer some more. Let's bring Dan up. Hey, Dan.
Yeah.
I know Georgette's going to share her screen. All right, so we have Dan Rush today, who is principal and owner of FWH Associates. He's been in the Toms River-based firm since 1994. As a principal of FWH, Dan is responsible for the supervision and the preparation of construction plans, construction specifications, and transition reports for the condominium and homeowner associations. He's also responsible for all the phases of project planning. Ooh, my screen just went blank. Bear with me, guys. Sorry about that. For project planning through design, including representation at board meetings, testimony at public hearings, and construction observation. Today, Dan is going to be discussing the electric vehicle charging stations and your community's need for a plan. Welcome, Dan.
Thank you, Jackie. Appreciate it. And good afternoon, everyone. As I said, I'd like to thank Jackie and thank CAI for having us today. I'm happy to present some information on electric vehicle charging stations, which are coming our way. Georgette, if you could, there we go. All right. So my presentation today, everyone, is a general presentation. In our industry, there's a lot of different ownership communities. There's a lot of different construction type communities. So what we've done is try to put together a real quick summary for you as community boards and residents begin to implement or to install these electrical vehicle charging stations, which some communities already have. So we're going to go through the legal aspects, so the legal responsibilities, the association's responsibilities, and then the impacts on the homeowner. You can go ahead, Georgette. Great. So as everyone knows, the general trend in our country is towards clean energy, and electric vehicles are one of those trends that we're starting to see. So the government of New Jersey has been working on electric vehicle legislation for a couple of years, since 2018. And A3367 became law on October 19th, 2020. So this fall. So a couple definitions you need to understand as we go through this. A designated parking space, it simply means a parking space that is assigned to a unit owner, specifically designated to a unit owner. This would be a garage parking area, whether it's a single garage or in a parking garage. So these are areas that are specifically designated to the unit owner for parking, whether it's one space or two spaces. An electrical vehicle charging station kind of is what it says it is, but what we mean is a charging station that's in compliance with the state codes, with the state uniform construction code, and is for the purpose of the legislation that was passed. The minimum level of a charging station would be a level 2 charging station. Now, this is something I'm going to talk about as we get down the road on this presentation. And a reasonable restriction would be an association has the ability to put a reasonable restriction on its owners. And this would be, as long as it doesn't significantly increase the cost of the charging station or significantly reduce the efficiency of the charging station, it would be considered a reasonable restriction. Okay, so the main points of the legislation was it authorizes individual unit owners to utilize the common elements to install a charging station. This would mean that in order to get the electric to the charging station, to this designated space, the unit owner has been empowered by this legislation to use the common area, to run utility lines, to perform the construction. Okay, now, and it also gives the association the ability to adopt rules, how to use the charging stations, how to install them. So most associations have guidelines for installing a basketball hoop at your driveway, changing the color of your front door, use of the clubhouse, as Martin and Tana talked about. So we have all these guidelines, but there needs to be guidelines. That's going to be the crux of my presentation for the associations, to begin the process of developing these guidelines. But so this legislation gave us the ability to enact these guidelines. One important part, which is probably what most people will come away from this presentation, is that the The legislation actually says that if the association has 60 days to approve the application, or it is automatically approved. So that 60 days is going to go quick, and that's why I am a big proponent of the associations working on guidelines now, maybe forming a committee to specifically address this issue to work to the board. Again, as I started out, I'm probably talking to folks who have 6 units in their community to 5,000 units in your community. How you will go about enacting these guidelines, developing these guidelines, is going to be based on how your association works. So obviously a 24 unit community has a little bit less chance of thousands of charging stations being constructed, right? But a bigger community, it could be a bigger deal. It could be bigger implications as far as how these guidelines are enacted. Okay, so unit owner responsibilities. So the unit owner has to comply with the association's architectural standards that associations either have in place, most don't, but they're going to prepare. You have to use a licensed contractor to install the charging station. Obviously, that contractor is going to be either a licensed electrician, or a contractor will sub out to a licensed electrician to install the necessary electric, make sure everything is safe and in compliance with the association's architectural standards. More responsibilities. The unit owner is going to have to demonstrate that they have adequate insurance protecting the association and other unit owners. This insurance must be maintained for the life of the electric vehicle charging station. The obligation to maintain this charging station in the future, the obligation to let a future owner know that if they buy their unit, they have this obligation to maintain this insurance, to maintain the charging station itself, and to comply with the association's rules regarding the use of the charging station. A unit owner would obviously pay for the electricity that they use in charging their vehicle. And then the association has the ability to put a reasonable application fee, it may be called something else, but a reasonable charge to the unit owner to hire an engineer to review the application, to hire or to use the association's attorney to review it and put any language together in any kind of an agreement. So those are the responsibilities of the individual unit owners. Okay, regarding the association's preparation and work that you should be doing now to get yourself in a good position to have these charging stations approved effectively and have them really function in the way that you want for your individual community. You know, I think Tana mentioned earlier that, you know, they gave you guidelines for COVID in the clubhouse. Well, every community is different. You know, maybe you don't want to do what the guy down the street does, and maybe you want to manage your electric charging stations a little differently. Every community has its own culture, its own personality, as do boards and unit owners and all that. So you're going to have to customize this. And one of the ways to go about doing that is to work with your attorney. Okay, your attorney is going to have to amend your documents to make sure that the parameters that we're putting in place, the approval process, follows your documents, much like it will for any other architectural modifications or applications that your homeowners make. But this is a new law. This is definitely something that I have been working with associations on as a team approach. The property manager, the association's attorney, and the engineer all have to work on this to create a good set of guidelines and a process that allows these charging stations to be a benefit to the community and not a burden. All right, next, Georgette. So in order to do these guidelines, proper preparation, you need to put in a process, come up with some standards, eliminate any unnecessary work, streamline the approval process. Again, we discussed that 60-day timeline, 60 days in the community association world. To other industries, it really goes quick, right? I don't know if you meet once a month, maybe some committees meet twice a month. Again, depending on the size of your community, if you miss a meeting, you could only have one meeting to review the application. So again, effectiveness, efficiency of the guideline process. You have to update your documents to include all the details that you want for the exterior modifications, right? So you don't want to end up with 15 different looking charging stations, 15 different configurations of parking stalls, confusing numbering systems. So real important to come up with standards and create a standard for the unit owner to use for the application process. A simple, very informative application and application instructions is going to be very critical, because if you don't do it that way, you're going to get different contractors are going to submit different things. Their interpretation is going to be different. We've all worked with contractors, different contractors. Everybody's idea of a perfect application is a little bit different. So very important to make them simple, easy to follow, and clear. And then, the unit owner is going to provide an approved electrician and an approved contractor. But one of the important team members of this would be the vendor that the association would approve to allow to install their charging stations in the community. We have Comcast listed as an example. So it would be a very similar situation to Comcast supplying cable to your community. Larger communities and smaller communities may have a limitation of which vendors can bring services into the community. And for these charging stations, a great thing for associations to do is start meeting with these vendors ahead of time, see what they offer. This is a relatively new field. The vendors are the ones kind of breaking trail here, and we need to follow them, take their experiences, what they've learned. In speaking with a vendor of charging stations last week, there are places that have already implemented them. There may be folks on the call who are connected to a charging station right now. So they've already been implemented. There are some rules out there and some mistakes you want to avoid. So getting these vendors as part of your team is really important. One thing I want to point out, that's fine, Georgette, you can leave it there, but there is a part of the legislation that allows the association to delay reviewing the applications if they believe the infrastructure of the community does not have the capacity to accommodate these charging stations. Okay, so that 60-day rule, that's again why I mentioned we need to get the lawyers involved in this process. That 60-day rule seems to have a mechanism where it can stop if the bones of your community, the infrastructure of your community are not able to support these charging stations, okay? So is it a first come, first serve basis with these unit owners? I don't think you want to do that. You don't want to have 15 people sign up, they get their charging stations, but unit owner number 16, you can't tell them there's no more room. They have to wait a year until the power company comes in and does any work. If anyone has had the joy of working with power companies, you have to realize they have a service area. A monopoly might be a good term to use for them. So their response is not always the best. And if you have to put in some new electrical main feeds to your community, that could literally take 6 months, a year. It could take a couple of years. So this is a new law. It's going to have growing pains. We're going to have to see how it works through the real world. But just something to keep in mind. I mentioned team and getting a team together. Your power company probably should be consulted. I mentioned earlier, a committee should be put together. If you have a large community, I would say you should have a committee formed. You should meet with vendors, meet with your engineer, and get the power company involved. Get a licensed electrician involved. See what you're up against. Create a set of known characteristics of your community and have them ready for that first application of a charging station comes in, so that you're ready for it, so that you can deal with it effectively. Okay, so the details regarding these stations. So if you wanted to put in a charging station, you're going to have to get an electrician. It may be known, but you're going to have to determine what the capacity of your area is. What is the load that you can add to your electrical system? These charging stations are put in garages, designated parking spaces. They can also be put in clubhouse parking areas. For communities that are single family homes, communities that are townhouses with a garage attached, it's a pretty easy process, these charging stations. You're going to likely require that they be put into the garages. It would be treated as a building permit application with the town because it's going to be inside the garage. An electrician's going to install it. We don't need any lighting. We don't need any concrete to be poured to do this. Pretty easy, just like changing your storm door on your main entrance, maybe, you know, typical architectural application. But for folks who have outside parking spaces, designated spaces, it's going to get a little bit complicated because now, in theory, you could have 50 of these charging stations pop up over the next few years. So, which is why we need to have these standards. Now, I mentioned the level of the charging station. I mentioned it earlier. Sorry to put you off a few minutes to clarify that, but what the legislation is referring to is level 2 chargers. Now, a level 1 charger is your typical charger you're going to use on your house electric that you have now. It'll probably take you at least 24 hours to charge your vehicle. They're not very convenient. I don't know anyone in my household who goes more than 24 hours before jumping in their car. So certain circumstances it might work. But the level 2 charger is a charger that can give you about 12 to 60 miles per hour on a charge. So you could get a good charge within a 4 or 5 hour period. This is the charger that most people are going to put in their homes or going to put in their own parking space. A level 3 charger, now that's a commercial charger. That's what you would put in the clubhouse parking lot. 1 or 2 cars could hook up to it and charge in a half an hour or 60 minutes. And you can get up to 240 miles off of an hour of charge. So these would be the stations you would see at the rest stops on the parkway or in the turnpike in your travels. So they're more of a commercial model. They, again, would be used in the common areas. Next, Georgette. So there's different styles. Obviously, this will be determined by the unit owners. A floor mount, bollard style, mounted to the ground. Okay, that's a clubhouse model. That would be what you would put in the parking lot. A wall mount would go in your garage, would obviously take up less space than a floor mount. And they do make a ceiling mount where you can pull the cord down from the ceiling. You do need a spot on the wall to put the hook for the cord so you can reach it. And you got to be careful you don't put your garage door up and block the charger, but hopefully your contractor is gonna make sure that doesn't happen. But those are the 3 kinds of styles. I will say when you look at the common area ones that would be in the clubhouse parking lot, you need to consider a few different things. You need to consider snow removal, lighting, security of the area, handicap accessibility. If you're going to build a public charging station in your clubhouse parking lot, I would say you need to make it handicap accessible. And you need to also put it, if you're thinking about cost, is you need to construct it somewhere near a power source, right? So somewhere where you can grab the power cost effectively. All right, Georgette. Okay, here's some examples of the type of current, the type of power we're talking about for these level 2 chargers. Now, if you're going to, if a unit owner is going to install the charger, they're going to use their own licensed electrician. If an association is going to install a common charger or have someone involved in the review process, you're likely going to get an electrician who works in your community, somebody you have experience with. There are different vendors that can offer you a roadmap to doing this. ChargePoint, for example, is one of the largest of these providers. They've been very helpful to FWH in our projects. They will provide 3 bids from a licensed electricians, and they want to get these devices installed and in use. So that's what they do. All right, next, Georgette. So is Jackie giving me the peace sign? All right. So the shared common chargers that you would put in your clubhouse. Again, the vendors that offer these, they have apps and software that go along with it to manage the users, to make sure that there's a car hooked up to it as much as possible. That's going to generate revenue for the association. And to create rules, just like every other rule, clubhouse rules, things like that. So these vendors have these great apps and software. It's pretty idiot-proof to use these chargers. There can be penalties if somebody puts their car there and leaves it there for 2 days, they get charged for what they would normally be using the electricity on. Now, as far as FWH's guidelines, this would be any engineer that you choose to work with. When we do guidelines for folks who are going to do any kind of architectural work, we always like to provide a sample plan, a sample list of the information they need to provide us. It gives us a great, it gives you a better chance of success. So you can go ahead, Georgette. Just to give you some real quick costs, folks, a designated charging station put into one spot is about a $10,000 number. If you're going to put a common charger into your clubhouse, you're going to have 2 ports on it, so 2 cars can use it at once. It's about a $20,000 number. Maintenance is relatively inexpensive. This is an electric device. There's not a lot of moving parts on it. It's not like a fuel pump where we have pumps and diaphragms and things moving. It's really just electricity, so it's a very small maintenance fee. The software usually comes with no additional fee. They want you to use their product, but there are some fees with that. But again, the vendors can go over these details with you. There's a lot of variations with this. This is a very quick presentation. Definitely a lot of work goes into making this happen. For the power, if it's in your garage, on your garage wall, obviously it's going to be metered and you're going to pay that bill. For common chargers, it can go to a credit card on your app. And as I said earlier, the association will get most of the monies. Obviously the vendor has a VIG in it and is going to get a percentage. But it's a great system. I've seen people use it, very simple to use. So that's, I think, it. Oh, okay. So remember that 60-day timeline is really important. This is what homeowners need to know. The association needs to be aware of that 60 days, but the homeowners need to submit an application. Again, give them a good example. The contractor has obviously a lot of obligation here with the scope of work, preparing the plot plan, filling out the permit, having a copy of his license, all that insurance, but those are typical requirements. Your town will be involved with the electrical inspection. I strongly recommend that you have an independent third party inspect it as well as the township inspector. Someone like FWH or any of the other outfits can certainly handle that to make sure that it's constructed properly and doesn't become a maintenance burden. All right, I'll be happy to take some questions, Jackie.
All right, great. You have lots of questions that came in. All right. Are designated parking spaces also for outdoor parking areas in communities where the units do not have garages or driveways?
Yeah, some communities will have designated spaces where they park. For a community that does not have any designated parking now, the electrical vehicle charging stations may create the need for it. Because certainly if someone puts the money into an investment of putting in a charging station and when they get home from work, their neighbors park there and has gone to Florida for a week, that's not going to be good.
Are we required to install charging stations in the common parking lots?
No, there's no requirement that you have to do that. I work with a few communities right now that we are exploring the options of putting in these common charging stations in the hope that it might reduce the need for individual unit owners to put them in.
If a unit owner installs a charging station, can they be required to remove it when they sell their unit, providing the new owner does not want to keep and maintain it?
I think that would be a condition.
Yeah, I can take that one. Basically, the law states that the owner, the successive owner, is responsible for replacement and damage, and also they're responsible for disclosing it to any prospective buyers that it's existing and that any related responsibilities that they currently own.
So Jackie, I think the way that would work is if I'm buying a unit and I do not want that charging station, I'm gonna make a deal with the seller that either they're going to take that cost of removal out of my sale price or they're going to remove it before I buy it.
All right. If an owner has already installed charging stations in their garage without notification or approval from the HOA, can the HOA request documentation after the fact?
Yes, I would think they could. You're kind of getting into the legal realm of things, so I would say they need to consult with their attorney. But I would think you certainly should request the permit, the copies of the permits from the township.
All right. Homeowners are allowed to install charging stations in their private garages. However, is the association, oh, no, you already answered that one. They're not required in the rest. All right, that's all I have about the charging stations for right now. If anybody has anything else, please
Okay.
feel free to put that into our chat box. Martin and Sean, I don't know if you want to pop back on. If you have any further questions for them as well, please feel free. I'll give you just another minute to put them in. I know Martin on the back end was answering some one-off questions in there, so thank you. Just give everybody just a minute. Well, in the meantime, I just want to thank everybody for participating today. Thank you, Dan, Georgette, Martin, Tana. Really appreciate your participation in this. This will be available on the CAI website if you'd like to rewatch it. And for our presenters, we are getting quite a few questions. Can we make the PowerPoint presentations available to the attendees? So if you can send that over to me and I'll make sure everybody has them. Oh, okay. I have a question. I don't know if we can specify this a little bit further. What about cord running over sidewalk or grass?
Yeah, so that would be, that's actually a great question. So that is why we want some really good guidelines so we don't have conditions like that ever happening. But no, you wouldn't approve anything that would have any cords going across a sidewalk, anything like that. So great question, but that's got to all be accommodated in the guidelines. Most of the cords are 23 feet long. A perfect scenario is it's in the front of your parking space and you just pull it around your car. You don't, some of the models actually have the port in the very front of the car, so you just pop it right in. So yeah, great question.
Martin and Tana, I think this one's going to go to you. The March 2021 revision also required that you set aside an area in case someone gets sick while at the pool. The prior rule only imposed this on pools of 500-person capacity or more. How do we do that at the smaller pools at most of our community associations?
I think the answer to that is you have to look at it on a case-by-case basis. And, the requirement is that you do have to designate this area. And so if you don't have an area where you're capable of designating, sealing off an area and designating it, then you may reconsider reopening. But I think that as you look at these and you peel back the layers of the onion, and you wouldn't just work with your legal counsel, you would also work with your pool management company whoever is doing your ambassador services to set that up. And of course, most importantly, your management company.
Yeah, absolutely.
All right. Well, it looks like that is all the questions for today. So thank you all again, and we'll see everybody at the next Wednesday webinar on April 21st. Have a great day, everybody.
Thanks,
Great
everybody.
job. Thank
Hi,
you.
thanks, Jack.